the flaws of the two-judge bench judgment given by Supreme Court on Tamil Nadu's governor. The judgment is related with the governor's power to assent, which is provided under Constitution under Article 200 and 201. Under 200, it is simply the power of governor to give assent to the bills which have been passed by state legislatures. So when the bills are passed and they are presented before governor, and 200 article says that governor must assent and should declare his intention whether he withholds the bill or he is sending the bill for reconsideration. This provision related to reconsideration was added by 44th Amendment. So there is no time limit. What is written is as soon as possible. The governor is supposed to give his assent as soon as possible. 201 says that governor can reserve some of the bills, especially which are related with the potential negative impact on high courts in the state, for the consideration by president. In Tamil Nadu, something was going on. Everyone is aware of it. The governor of Tamil Nadu had kept more than 10 bills for more than 1 year without giving assent. Following flaws have been made by Supreme Court. One, they have invoked Article 142. Article 142 is such an extraordinary jurisdiction of Supreme Court that whenever it was used in the rarest of rare cases, one, and two, generally, although not always, by a constitutional bench. But in this case, 142 had been invoked by an ordinary two-member bench. Now question is, can Article 142, that is an exclusive jurisdiction of Supreme Court, be invoked for the legislative purpose, which is to be completed according to the rules of procedure provided under Article 118? And 122 says that courts will not interfere in law-making related provisions. There is explicit restriction from intervention by the courts in lawmaking process. Now, can 142 be invoked to complete the lawmaking process? Second is in Constitution under Article 200, what is written is as soon as possible. Can this deliberately chosen terminology, as soon as possible, be converted by a two-member bench into 1 month period? As soon as possible, can it be converted into 1 month period? There could be many emergency which can compel governor to keep the bill under his consideration for more than 30 days. Maybe he has some doubt related to intelligence, and if he is seeking some intelligence assistance from central agencies, or if governor in case is hospitalized or suffering from some disease, and in the meantime the charge of his state is not given to any other governor of any other state, so by reason of health, maybe by reason of resignation, removal, there is vacancy and the charge is not given. There could be many other possible reasons, and that was the main reason why constitution makers did not specify the time limit and they chose the word as soon as possible. Now Supreme Court goes on, and not Supreme Court, this is two-member bench. If it has to be changed, it can be changed only by a constitutional amendment. But can a two-member bench do what even the two-third majority of Indian Parliament cannot do? Then, if Supreme Court can keep on determining the time limit within which the governors and president have to give their assent, then should there not be time limit also for Supreme Court judges where 85,000 cases are pending? If it is asked how long time is required for Supreme Court to give the complete justice, why can't Supreme Court invoke Article 142, complete justice, against its own pending cases? So there are very serious constitutional and political question. This is one of the weakest judgments given by Supreme Court. Although I always oppose any casual approach to be taken against Supreme Court, that is an institution. If some judges give some ad hoc judgment, then it doesn't mean that we must start attacking the institution or institutionality of Supreme Court. We must counter the judgments only on the basis of merit, fact, evidence. So these are the fundamental flaws. These are serious constitutional questions which need to be considered by a larger bench, constitutional bench, and that's why government must take immediate action to file a review petition as soon as possible. If the larger bench, if constitutional bench wants to convert as soon as possible into 1 month, then let it be so. Let it be said in written by a constitutional bench. Even then, the question is not coming to an end. Can Supreme Court benches change the language of constitutional provisions which were made very deliberately for the purpose of future concerns or to handle the future emergency situations? So this is a very weak judgment. On the one hand, it appears to be a historic judgment, but there are fundamental flaws, and in times to come we must see that these flaws are remedied. Maybe they provide that as soon as possible should mean 30 days. But if it has to be, then it must be declared by a constitutional bench, and let us see what a constitutional bench has to say on this. So I will continue on other constitutional questions.